Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be Los Angeles forcing landlords to lose. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening live, the name of the song was Lonely People, performed by the group America. That was actually written by Dan Peek and his then wife, Catherine Peek, and it was released by the band in 1974. Now, the inside story regarding that is pretty personal. It essentially was Dan's response to the Beatles song Eleanor Rigby and its bleak portrayal of isolation. Dan had become discouraged from being on the road so much, traveling with the band, and just in general with the music business. But his then wife, Catherine, encouraged him and to continue on. And they wrote the song together called Lonely People as a hopeful counter message to anyone who felt stuck or alone. And hence the line, "Don't give up until you drink from the silver cup." Okay, let's start. And that is, I'm going to start with an announcement. Oh my God, we have an announcement here, ladies and gentlemen. And I'm going to pull this up right now. And that is on August 20th, the AOA, the Apartment Owners Association, is having its $1 million trade show. And that's again at the Long Beach Convention Center. It starts at actually, the first seminar is at 7:30 in the morning, but it's a whole day event. I encourage everybody to go out there. Did I mention? It's free. You'll get to see a lot of vendors at their booths, how to operate your buildings more efficiently and economically. And also you can participate in any of the seminars. Now, yours truly, Dennis Block, is giving that seminar at, my seminar will be at 1:15. We're going to talk about how to prevent yourself from getting sued for discrimination. And also for habitability claims. So come out there. I have a booth right next to the seminar room at Seminar Room A, and come up to my booth. You can take a selfie with me. We have brochures and hands out, and you can actually get your questions in. So I encourage everybody, August 20th, Long Beach Convention Center, and sponsored by the AOA. Okay. Let's move on to the show format, and that is that we always start with an opening topic. And then after the opening topic, for those people that are in the Zoom meeting room, if you electronically raise your hand, and I suggest that you do that now, I'll be happy to call on you, and I call on you in the order upon which your hand was raised. So please feel free to do so at this point in time. If you're watching this on YouTube and you're saying, gee, how do I get in on the Zoom meeting, which is, of course, every Saturday at 3 p.m., it's pretty simple. Go to my website, evict123.com. That's EVICT 123.com. And you'll be able to see the link there to join the Zoom meeting. So if you have questions, please feel free to do so. However, if you are watching on YouTube, please feel free to leave your comments in the box permitted for on YouTube. Also, if you are watching on YouTube, help me out. Hit that like button and also subscribe to the channel because it really does keep this show moving. Okay, so what's the opening topic of the day? The opening topic of the day is Los Angeles instituting new procedures for landlords to lose. Los Angeles is instituting new procedures for landlords to lose. It's unbelievable, ladies and gentlemen. And let's first start with a new law being instituted by Los Angeles County. Now, this is only for those residential units that are located in an unincorporated area of LA County. So if you're in, for example, the city of Los Angeles or Beverly Hills or Santa Monica, those are incorporated cities. But if you have property located in an unincorporated area of LA County, they just passed the new rule. So what's the new rule? And that is that your individual unit, regardless of what heat wave is going on, that unit, that apartment cannot exceed 82 degrees. It cannot exceed 82 degrees. And if it does, then you have a responsibility to install air conditioning or different building materials, like putting some sort of protection so to keep the heat out, because now you have an obligation to make sure that that apartment doesn't go above 82. And did I mention this is all on your dime? There's no retribution from the state, from the county, or any reimbursement from your tenants. You have to start putting in air conditioners in this. Now, the reason why the county instituted this was because they had compiled data from the California Department of Housing, Community, and Development. And they found by this data that 460 deaths occurred due to extreme heat from the years 2013 through 2022. This study came out just this year. So that means for that 9-year period, 460 people died from extreme heat, which was approximately 51 deaths per year. But let's consider the expense to the landlord. They have to bear the cost of putting in air conditioning or doing this building material to keep the thing down. There is no, again, reimbursement. And for example, the county, they're giving you only a whopping 2.565% rent increase, or 3.565 rent increase, considering whether you're either a general owner or a small property owner. So they're giving you no rent increase, but they're now expecting you to be putting in these air conditioners. What if, for example, you had a 12-unit building? It's going to be astronomical, assuming you have to put in these 12 air conditioners to placate the county because of their latest study, their data stating that all these people died. Well, this is totally fraudulent. This data, this survey of how many people died is totally fraudulent. And I do want to show you this, so bear with me. What we have here, ladies and gentlemen, is a total fraud by the County of Los Angeles. The county cited a study by the California Department of Housing and Community, and this data is totally a fabrication to justify forcing landlords to absorb these additional costs. The truth is that the report came from the California Department of Insurance, and the alleged deaths were not limited to rental units. The deaths were determined by researchers comparing the total number of deaths during a heat wave event to the expected number of deaths based on historical averages for the same period. The difference is attributable to the heat event, even if not all of the deaths were officially listed as heat related on their death certificates. This bullshit data is now forcing landlords in unincorporated areas of LA County to install air conditioning units or other building material. This is a complete fraud upon property owners. Let's think this out. All they did was determine that during a heat wave, how many people died. When it wasn't a heat wave, how many people died, and therefore any extra deaths that occurred are attributable to heat wave without looking at how they did it. If more people got into a traffic accident, would make no difference. That's part of the 460. This is a total fraud on the part of the County Board of Supervisors to just do what they do best and to wreak havoc on poor property owners. Okay, let's move on to new procedures by the City of Los Angeles. So let's go over what their current procedures are, which are totally different from any other place. And again, I'm going to share my screen with you on that. Okay, so you're seeing two notices. If you own property any residential rental unit in the city of Los Angeles, you have to have these notices posted if you're subject to the rent stabilization ordinance. If you're not subject to the rent stabilization ordinance, then you only have to post the notice that's on the right side, the City of Los Angeles Renters Protection Notice. If you don't do that, what's going to happen is you will lose your eviction case. Okay? But let's move on again with regard to the requirements just for the city of Los Angeles. Okay. And again, they're designed for you to lose your eviction case. Now, in your notice, your 3-day notice to pay rent or quit, you have to state how many bedrooms. You don't have a bedroom count in that notice, you lose your case. And why did they want you to do that? Well, because you can't serve a 3-day notice to pay rent or quit unless the amount, the total in the notice, exceeds the fair market value. So let's go into that, the fair market value. And I've talked about this before. So if you have a 1-bedroom that's going for $2,000 and they don't pay you rent for this month, August, then you have to wait until September. You've got to waste another 30 days before you can even start an eviction, even serve a notice, because if you filed that lawsuit now, your case would be thrown out of court. Okay? So again, the city of Los Angeles is forcing landlords to lose more money. They're delaying any eviction case unless you're above the fair market value. Now, clearly, if you're renting out a unit, you never want to go below the fair market value. In fact, you probably want to go $200 higher because it changes every year in October. So take a look at these figures now if you are renting out. So if you think that the city of Los Angeles is trying to promote lower rent, just the opposite. By having this fair market value chart, landlords are now going to be renting out their units for more money. Okay. But then they started something new. Another form. Can you believe this? Again, this is just for the city of Los Angeles. And I'm going to now show you this last form that you have to have posted on your property. Who even knows about this stuff? By the way, all these forms are on my website in the free form section entitled at evict123.com. Go to the free form section. But right now, here's another form. This form informs the tenants that during an eviction case, they have the right to counsel. Now, I don't know about you, but I'm sure you've heard in the news that the city of Los Angeles is facing a $1 billion deficit, thanks to our wonderful mayor, Karen Bass, and our other city council people. $1 billion deficit. The mismanagement is out of its mind. So what do they do in the face of a $1 billion deficit? They're going to give tenants, any tenant they want, who qualifies, and believe me, they'll all qualify, the right to an attorney. That's going to drive up the cost of your eviction case, and also it's going to obviously elongate the case if there's an attorney on the other side. Now, not only, and they're so tricky, not only does this notice has to be posted in a conspicuous spot on the property, you have to include this notice with any termination notice. So if you're serving a notice to pay rent or quit, this notice has to be accompanied. If you're serving a 30 or a 60-day notice, you're serving a notice to perform or quit, you're serving a nuisance notice because the guy shot up the premises, this notice has to be attached. The notice is not attached, you lose your case. This is just another boondoggle by the city of Los Angeles for landlords to lose their case, and hence the title for my opening topic is Los Angeles Instituting New Procedures for Landlords to Lose. And that concludes my topic, ladies and gentlemen. We're now going to open it up to those participants in the Zoom meeting room. If you do want to talk to me, please electronically raise your hand and I'll be certain to call on you. I do see that we have some spots open, so take a chance if you want to ask me a question. Please remember that this meeting is for informational purposes only and doesn't constitute legal advice. And if you are asking me a question, please just ask general questions only. If you have a specific case with me, please reserve that by calling the office. If you are talking to me and you have a camera, please leave it on because it does make it much more enjoyable for people watching and including myself. And again, if you are watching this on YouTube, please hit that like button, subscribe to the channel. If you've got questions, leave it in the comments and I promise you I will get to it. We're going to open it up to questions now. The first person I'm going to ask to unmute themselves is Arlene. How are you today?
Hi, Dennis. Can you hear me?
Perfectly.
Oh, great. Hope you're having a nice Saturday. This is a little bit out of your wheelhouse, so maybe you can just maybe refer me to the right place. LARSO, the RUBS program for ratio utility. I have two tenants that are on it, and then I have a long-term tenant that I didn't put on it because I was under the impression that with they've been here about 10 years that you can't make changes to the lease or change anything. So I don't know if it's considered an increase or not, but LAHD won't help me. They sent me to the county. The county sent me back to
Well, I
LAHD.
can help you. I got the answer to that question. As to new
Okay.
tenants coming in, you can certainly enroll them in the RUBS program. That's a
Which
way,
I did. Yeah.
but it's
My
not as to
concern is the old
existing
one.
tenants. Now, for people who are listening who don't know what we're talking about, if you have only 1 meter for electricity and gas, for example, then there's a company that will come out that will measure how much is going to each unit. They install some equipment. So this way, you're able to take that charge for any utilities that are being borne by that one apartment and put that onto their rental agreement as an additional charge. But again, that's only for tenants who are joining the tenancy. Any existing tenant who didn't pay for his utilities because there was only 1 meter, so obviously it was borne by the landlord, that tenant is free and clear from joining that RUBS program. But you can just imagine, Arlene, if your property where you're paying all the utilities for your tenants, and then if your property was located in an unincorporated area of LA County, you can just imagine if you're not only you're going to have to put the air conditioners in, you're going to now have to pay for the
Okay.
additional electricity costs. So this is crazy going back to what the County of Los Angeles is doing.
Yeah. And this new AB 130 is insane too, which is the HOA limiting any kind of fines for anything to a one-time $100 fee.
You know, I meant to talk about that. I'm glad you reminded me. I wanted to put that as my opening topic. So,
Maybe next week.
okay, maybe I'll talk about it next week, but I did tweet about it if anyone wants to see it. It's on my Twitter account, which is x.com/Dennis Block. Anyway, Arlene, thank you very much. And we are going to move to Juan Calderon. How are you, sir?
I'm doing good. How you doing, Dennis?
I'm good, thanks.
I have just two small little questions. Last week, I spoke to you about when you have the 3-day notice, say they don't pay, you give them the 3-day notice. Now, at that time, when do they have to pay the late fee? Like, say, do I have to wait until it's, say, 3 days or 2 days and then charge them the late fee of that or what?
Well, the late fees are determined based on the terminology in your rental agreement. So if it says that a late fee is incurred if the rent is not paid within the first 5 days, for example, and assuming you have a legal late charge provision because there has to be special language, then after the fifth day you can charge them. Now, if you're serving a 3-day notice, for example, on the second, which you have the right to do, then you're not going to be, if the tenant doesn't pay, you're not going to have the right to now ask for the late charge. I guess you could subtract it from the security deposit in certain circumstances. But let's pretend the tenant does pay the rent. You could serve immediately a notice to perform or quit, giving the tenant 3 days to pay the late charge that was incurred because the rent wasn't paid within the first 5 days.
Okay, and then I live in the city of Whittier, and I saw you put those forms. It's not a rent control. Do I have to, you said that, do I have to post the city of Los Angeles eviction on?
No, the none of that for if you have an incorporated city that is not Los Angeles, then those forms have nothing to do with you. Those
Okay,
are only for the city of Los Angeles and unincorporated area of LA County. Some parts of Whittier, by the way, are unincorporated, so you would have to post some notices that the county has, but not for the city of Los Angeles.
Thank you.
And thank you. We are moving on to Jeff Home Pro. How are you? Jeff Home Pro, I'm going to ask you to unmute yourself. Okay, Jeff, we're asleep at the wheel. Moving on to Harold.
Sorry. Oh, I'm here.
Okay, good. I'll talk to you. Go ahead, Jeff.
Okay, sorry, Dennis. I just set up Zoom and I don't know all the buttons yet. Hey, I watched your security deposit video, and it kept talking about you can do 2 months rent if it's more than 4 units. I currently lease a home that's in a family trust, and I was going to sublease to some other people. What would the security deposit be for?
Well, when
that
you say you're going to
situation?
sublease, you only own 1 unit then, so you can get a double security deposit if you're going to be renting out rooms.
Yeah, I'm renting out some rooms to another person, so I didn't know
Yeah,
what the
no,
term
the
unit.
law
if it meant
says that the law says you can only collect a 1 month's rent as a security deposit. However, the exception is if you own no more than 4 units on 2 individual properties, then you can charge a double month's security. So you only have 1 single family home, even though you might have 4 tenancies in that house, you only have 1 single family home, so you can charge a double security.
Thank you so much, and I would like to call your office and set up an appointment with you too.
Happy to do so. Give us a call, 1-800-77-EVICT. Thank you very much, Jeff. Harold Rhodes, how are you today? Mr. Rhodes. Okay, Harold, I think you're having a little problems today. Let's move on to iPhone. I'm going to ask you to unmute yourself. By the way, there are some spots open, so if you do want to ask me a question, please electronically raise your hand if you're in the Zoom meeting. And iPhone, are you there? Oh, no, Harold.
Dennis, I'm here.
Okay, good.
I didn't you call me so soon. Okay, here's my question. Remember, we got over this theme that if I decide to take my place back, you give a 60-day notice on a single family, Los Angeles, just cause. My question now that there's new information about you have to have this legal form, do I still have to have that form that you just mentioned about right to an attorney when I do that?
Absolutely. It applies to all residential units in the city of Los Angeles. You have to serve that termination notice with that right to counsel.
Hey, but real quick, if I already gave him that right to cancel, like I already, have it put up so he can see it in a conspicuous place, is it redundant or I already did it?
You have to post this notice. I'm reading the notice in an accessible area.
Yeah.
You have to provide the notice to the tenant when issuing a notice to vacate. You got to do both.
Okay, there you go.
Oh, and I didn't even mention this, which I should have. Failure. Actually, let me share the screen here.
Yeah, let's see it.
And I want you guys to see this just in case you think I make this stuff up. If you look here, failure to comply with these notice requirements may subject the landlords to civil and criminal penalties as outlined in the tenant right to counsel ordinance. Can you imagine? You're going to be, because you forgot to serve a notice or forgot to put this notice up, you could be subject to criminal penalties. These guys are smoking something, ladies and gentlemen. So, Harold, you still there?
Yeah, I am. I'm in shock. It's one atomic bomb after another. Thank God you're at the helm.
All right, I appreciate that. We're going to move on to, sorry about that, iPhone. Now I'm ready to unmute you. Go ahead, sir.
Good afternoon, Dennis. How are you?
I am good, thank you.
I know I was watching one of your previous shows and you talked about the expiration date being on the 3-day notice to rent a quit. Now, when that case came down, I guess when they reversed their decision about that, adding that date, that expiration date, does that apply to any cases that was filed prior to that?
I don't think so if you had the correct language. If you see the notice that the appellate court ruled on, or the appeals court ruled on, it was a terrible notice. And then they decided to take it a little step further, saying that the tenant has to know when the notice expires. Because, for example, in that case, the notice was dated the day it was prepared, which was, let's just take a date on July 3rd. They didn't serve it until July 7th. So the court reckoned that, in fact, a normal person would think that the notice has already expired, even though our notices and most notices, except for that notice, specifically states that it's 3 days from when the notice was served. So in our notice that's on our website, evict123.com, we do require and request that you put in the expiration date. But for the notices that my law firm is serving, because I don't know exactly when it's going to get served, as most law firms don't, because you're giving it to a process serving company and you don't know exactly if they're going to serve it today or tomorrow. So we don't put that date in, but we make it very clear that the date that's on the notice specifically says the date this notice was prepared. It also says in bold letters, you have 3 days from when you were served with this notice. Now, we had a court case that came up where somebody filed a summary judgment motion to try to get rid of our case on the basis that our notice was defective based on this new appeals court ruling, but the court ruled in our favor. And this was even before we boosted our notices to make them even stronger, that the notice that we stated, which clearly said 3 days from the service of the notice, did it give the tenant reason to believe when that notice would expire. Okay? So I think we're good on that. So I don't think you need to. So if you use the standard notice, I think you're okay.
Okay, one last question. Now, I'm currently in a case with this tenant, and this tenant is requesting not a replacement key, but a second key fob. He had two key fobs. He lost one of the key fobs. Am I allowed to just not give him a
You
second
have
key
to
fob?
supply him with another key fob, but at his expense, to say, here, give me the $25 and I'll give you a key fob.
Okay, so I would have to give it to him,
Yeah,
the second one.
you have to give it to him, but he has to pay for it.
Okay. All right. Thank you, Dennis. Have a good day.
Thank you, sir. Now we're going to move on to Aaron. How are you?
Hi, Dennis.
Hello.
Longtime listener, first time caller. Um, I manage a couple RSO properties in the city of Los Angeles. And my first question, I've heard you speak a lot to this. So I understand minors that are original occupants, once they come of age, they're entitled to remain on the property under the original lease terms. That's correct?
Correct.
Does it matter if they left at some point and then came back as adults and parents have passed on? Does that change that scenario at all?
I think that's a great question, and it's a gray area in the law. So if the tenant, for example, the child moved, he was, let's say, in the unit when he moved in with his parents, then the tenant gets a job and is panning for gold in Alaska, has been there for a few years. Then the parents, for example, are getting a little elderly, so he comes back. I think you could make a decent argument, but it could go either way, that the when you moved out, that you terminated your rights to the tenancy, so you can't come back.
Great, appreciate that. And then, second question, I've heard you also speak a lot to. I know hoarding is a very sensitive situation with disability law and everything, but do you recommend the first 2 or 3 steps in terms of like addressing that? What's some good protocol to start that conversation to help mitigate and
Yeah, I don't believe that hoarding is a disability. I know you're going to get a lot of people that says that, and even if it is a disability, you have to allow a reasonable accommodation for a disability. But if you're hoarding, that's a safety hazard for the entire building, because that's easy for it to catch on fire. It's also a bedrock where pests can accumulate in those types of units. So I would certainly serve uh, the tenant with a warning notice, hey, you got to clean this up. And if he doesn't, then you have the right to serve a notice to perform or quit.
does it help to call like the housing department or the health department? Do you recommend that or?
If, if they issued an order to comply, that would be great. They're going to probably cite you, and the chances of them coming out probably are zero.
Okay, appreciate that. Thank you.
Okay, thank you. Moving on to Eric Chavez. How are you?
Hey, Dennis. So I got a question, but also clarification on this right to counsel notice now. So do we also have to attach that with change of terms as well? It has to be included?
No, it has to be posted in a conspicuous spot on the property. Now, again, we're only talking about properties, residential properties in the city of Los Angeles. And you have to include it when you're serving any kind of a termination notice. A notice to change the terms of tenancy, like a rent increase, wouldn't be that. There's no reason to do that.
Got it. Now, my question, so when it comes touching off on the other previous questions about far as like hoarding and, getting slow paying tenants to pay, keeping common areas clean, what can an owner do where it's being implied by the tenants as harassment of like when we just sending notices of, hey, we need you to provide proof of your renter's insurance. Hey, please keep the common areas clean. Hey, you're paying slow. So
If you're asking legitimate issues to your tenant, then this harassment is just what it is. It's harassment towards the landlord, and you can ignore that intentionally. Okay. If
yeah,
hey, by the way, are you going to pay me the rent? Oh my God, that's harassment. Hey, you're keeping all this stuff outside your unit. That's not harassment. Okay. So, but of course, our politicians have gone overboard with that, but that's not any kind of a case.
I see. Okay, so the only thing we could do is just continue document, provide the notices, and if it gets to a
And
point where
enforce your rights. You have the right to enforce your rights. You don't want a slum building where they've got their bicycles and their barbecues and their old couches sitting out there. I mean, it's insane.
But I mean, but pretty much it's gonna when it gets to a point where enough is enough. I mean, there's nothing I can avoid. I have to just call your office and commence an eviction action, right?
In fact, today I took in a case on Saturday where they were the tenant was given many warnings, get this stuff out of there. They had a couch and boxes and other assorted furniture, and they won't do it. So they're getting served with a 3-day notice on Monday.
Got it. Thank you, Dennis.
All right, thank you, Eric. Moving on to John Radich. How are you? John, I'll ask you to unmute yourself.
Hold down. Okay.
Hey.
So
Hello, John.
yes.
How's the
So
sun? Is it a little hot out there today?
it is little, but we have tree. We're sitting under the tree.
Yeah,
So
where are you? What city are
uh,
you at?
I'm in Castaic.
What is it?
Castaic.
Oh, Castaic. Oh, it's probably a little
Yeah.
cooler up there, I would hope.
No, not really. I don't know what temperature is, but anyway. So Dennis, I like to ask you. Seems nice guy. I've been recommended from my friend to your office, and one way I was happy the way you've been doing eviction. But no other way, I was not happy. I already talked to you regarding your attorney guy.
Okay,
And
John, part of the rules of the show, and I mentioned this right at the beginning, is that we do not talk about specific cases. If you have an issue with a case, I am happy to talk to you about it. Just give me a call on Monday, and I'll be thrilled to talk to you about that. But we don't
would I
talk
come
about
to your
specific.
office? Would
I,
I just come straight?
No, you don't come straight to the office, my friend. We do require appointments, but you can call and you get to talk to me all day long. Anyway, thank you very much, John. We are moving on to Jonathan Kennedy. How are you? Say hello, Mr. Kennedy.
Okay, now I think I'm unmuted. Okay, I have I waited until July 2nd to serve a rent increase that was greater than 10%, not realizing that the county board of supervisors had extended the emergency anti-gouging prohibition until October, right?
Well, it was the governor who did that. Did you go above 10%?
I did go above 10%, and I waited until July 2nd because that's when it expired on July 1st.
Yeah,
And
unfortunate. Is your tenant complaining?
no, I haven't heard a word from the tenant.
And when does
So
the
I
rent increase take effect?
90 days from July 2nd, plus 5 days for mailing. So July 7th, October 7th, I believe.
Okay, I think you're going to be okay. Um, if he squawks, then I would recoil and serve another notice come November 1st. Otherwise, I think you're fine.
Okay, so just leave it alone at
Leave it
this
alone and
point.
let's see if anybody gives you any opposition and states that it is a rent gouging under Penal Code Section 396, but due to the fires. By the way, and I've said this before, notwithstanding the emergency order, notwithstanding Penal Code Section 396, which says that during an emergency period, if you go above 10%, that's going to be considered rent gouging, and that's a misdemeanor. The truth of the matter is, there's another law which I've talked about ad nauseum called Costa-Hawkins. That law says that you can raise the rent on a single family home, townhouse, or a condominium, or properties built within the last 15 years. You can raise the rent to market level. And that law starts out with the phrase, notwithstanding any other law. So even if somebody tags you, I think you could easily argue saying, hey, listen, this state of emergency is great. I'm appreciative of that. But hey, what about Costa-Hawkins, which specifically says that this law is above every other law? So I think you're okay. I would let sleeping dogs lie and see what happens.
So if they did squawk, then you'll take it on as a test case, go all the way to the Supreme Court.
I would be thrilled. I would be thrilled to do so as long as you have one thing, and that is to pay
Money.
for it.
Well, I remember, I've heard you say that about the Costa-Hawkins many times, and I agree with you. So we'll see.
We'll find out together. But I don't think anybody's going to. If the tenant hasn't said anything yet, I don't think they will. Anyway, thank you very much. We are moving on to Rosie Mischief. What are you up to today, Rosie? Need you to unmute yourself, Rosie. It's your turn.
Hi, Dennis. I think I'm unmuted. Can you hear me now?
We can. You're making me a
Can you
little
hear me?
dizzy, though, but that's okay. Oh, Rosie. Now you're muted again, darling. Let me try to unmute you one more time. Hit your unmute button.
There we go.
Okay, darling.
I got it. Thank you. Okay. So I've got like a couple different things. And first of all, we'd love to know when your upcoming events and lectures are. If you could let us know about that. I had a question about collecting last month's rent. I know if you give somebody a notice, a 30-day notice, not for not paying rent, but for other reasons, like you want to, in my commercial building, why do you not collect the last month's rent? Is it sort of I'm just wondering if it's kind of like it's a confusion, or I don't know what the argument is for not collecting the last month's rent. And then
It's
the other
very
thing
simple. It's not to a
I
land.
wanted to know
Let
if you
me,
could talk
hello,
about
Rosie. Got it. Rosie, one question at a time. It's not
Yes,
to the, let me finish my sentence, darling. It's not to the landlord's benefit to call it a last month's rent. So it's to your detriment. If we're talking about a commercial property, you just want to call it a security deposit and you can get whatever you like. There's no limitation on commercial. So you get a 4-month security deposit. But for example, if you called it a security deposit of 1 month's rent and a last month's rent, then what happens is let's pretend on September 1, the tenant serves you with a 30-day notice that says, hey, this is my last month, and gives you that notice, which means you have to apply the last month's rent to the month of September. But then in the tenant's mind, hey, he didn't have the rent. He was just kidding with you, but you now got stalled off for 30 days. But instead of having a 1-month security and a 1 month's last month's rent, if you had a 2-month security come September 1st, he serves you with a 30-day notice and says, I'm out of here, use my deposit. You have to tell him, no, your deposits are not used for current rent. They're only used once you vacate the unit. So you can see right then and there, you'd be able to start an eviction case against this tenant. That's the reason you never call it a last month's rent. In addition, under California law, there is no such thing as a last month's rent. It's all considered a security deposit. What's your second question?
Well, about I called you about an issue. We don't have any case, which is kind of the opposite about what I believe was an illegal threat to evict us from a VRBO, and I believe the property manager that worked for out-of-state tenants was actually she was not licensed. She had no business license, and she had no real estate license. So I was thinking, just in general, for landlords, can you tell us a little bit about property management credentials and why it's important to have a real estate license to be a property manager?
Well, under California law, if you are a real estate manager, I'm not talking about just one person who's living in apartment number 2 and manages the building, but if you are managing real estate, you do have to have a license by the Department of Real Estate. I mean, it's just what the law is. And if you are going to reach out to a management company to professionally manage your buildings, you should ask them to show proof that they are a licensed realtor, that they have this management license by the Department of Real Estate. Anyway, thank you very much. Another question? Okay, thank you. Moving on to a number, 763385. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
Oh, hi. I missed, or I heard at the end of your beginning diatribe, you mentioned something about the 2 notices, and you said one of the notice, which I believe was the legal notice, right? The right to legal.
First of all, are we talking about the city of Los Angeles?
Yes.
Okay. And is your property under RSO?
No.
Okay. So it's a building that was built after 1979, correct?
Single family homes or condominiums.
Okay. So in that situation, you need to, and let's go share the screen again here. Bear with me.
Mm-hmm.
Okay. So you have to, if your property is not subject to RSO, then you only need to have posted in a conspicuous spot the notice that's on the left side, which is in blue, City of Los Angeles Renters Protection. But in addition to that, you also have to post the notice of tenant's right to counsel. You can see it right here as I go down. Post this notice, it's right there, in any accessible area of the rental property, such as common areas, etc. But also, as I told Harold, you have to also provide this notice when any termination notice is served.
But I thought you said if it was a non-RSO unit, you didn't have to do that.
No, you misunderstood me. All residential units in the city of Los Angeles have to have that notice posted, the one that was on the right side, and also the notice of right to counsel.
So both notices have to be posted.
Yep.
And you have to serve it with all those other notices, 3-day notices, pay rent, do whatever. You have to give it again then, right?
You got it, my friend.
And so at the beginning of your talk, you said one of the 2 notices didn't, there was a situation where you didn't have to, you only had to post one of the notices, I thought.
I think I just talked to you about that. If your property is RSO, both notices, if it's just JCO because it was built after 1979 or it's a single family home, then only the right notice needs to be posted. Anyway, thank you very much. Moving on to, I see iPhone here. Did you have another question?
I did, Dennis. I think quite a few of your participants are having trouble with raising their hand. I think the toolbar changed at the bottom, so you just have to go inside and raise your hand down. A little bit more difficult earlier today for me to figure it out.
Yeah, I'm looking at it. Sometimes it's in a folder, but I'm looking at mine right now and it says raise your hand. So, but thank you for that input.
It's in the reaction. So if anyone's trying to raise their hand, it's in the reactions.
Yeah, I've seen that in the past. So there's a button down there that says reaction. So, and then you can electronically raise your hand. I do see people are doing that, but a lot of times, I think what happens is that you don't have the Zoom meeting expanded. So it kind of flops it all into that reaction. But anyway, thank you. That's a
Okay,
really
no,
good hint.
okay, yeah, I did have the question about the tenant's right to counsel. When did that notice started being required? Is that something that always been required for us
No, it
to?
started, I think, July 1st. Actually, it's not even effective. You don't have to post this until it's this month, August 20th.
Oh, okay. So
But I'm
I
telling
okay,
everybody to do it now because you know what's
okay,
going to happen.
okay. Thank you so much.
All right, thank you. Moving on to, I think somebody new, Patricia Ramsey. How are you? Need to unmute yourself, young lady.
Hi, Dennis.
Hello.
Hi, first time caller. If long-term tenants in unpermitted structures in unincorporated LA County were never given this notice of tenants' rights.
Okay, well, before we move on that, we're way beyond that. When you're talking about unincorporated areas of LA County, you're leasing out an unpermitted unit?
Well, not me. I'm just asking. Um,
Okay, so if you're leasing out an unpermitted unit in the county, then you have to, number one, the tenant doesn't have to pay any rent, and you have to pay the tenant relocation. Let me share my screen with you again on this one. I just pulled this up. I'm getting pretty good at pulling this stuff up. So you can see here that if you're having the relocation, for example, for a two-bedroom unit, is $15,921 because you chose to lease a unit that was unpermitted. In addition, you have to hire a relocation specialist that will assist the tenant to move, and that's another $3,000. So you don't get to the point of, hey, I have to have these notices posted. That's irrelevant. You got an unpermitted unit. That tenant doesn't have to pay you any rent. He can live there forever for free until you take the steps, which are to serve the proper termination notices and pay him his relocation money.
right. And this person, well, this situation involves someone, a landowner with 5 rentals, 3 unpermitted, that put the property up for sale. And
Well, you can always sell the property with unpermitted
unpermitted,
units.
right, as long as it's
Just
disclosed.
disclose and then let the buyer deal with it. But if he's going to deal with it, then I would start offering those tenants the relocation money.
Okay, thank you, Dennis.
Thank you. Good question. We are moving on to Rosanna. How are you?
Unmute. There, how's that?
Very good.
Okay. I'll let you know that your name came up in conversation in a courtroom last week in Corona. The tenant's attorney quoted you as saying something. One of the issues that we had was there's a new law requiring that the date served be written on the 3-day notice. Okay.
Not exactly. Okay.
Okay.
If the one that my 3-day notice that I have online does have a space that says that the date that the notice expires, not the date that it's served. Okay. But in any event, if you have language in your notice that says that you have 3 days from when you are served, that's enough. That's all that the appeals court were talking about on that. So you don't have to have, quote, the date that it was served. However, I do have that on my website, the notice that I have on my website, which does state the date that it was served and also the date that it expires. But again, you can do it in generalized terms.
Okay, okay. Thank you. We are doing that. This particular case, however, was initiated prior to this particular ruling coming out.
Well, did
And
you use, for example, one of my notices or, for
no,
example, the one from one of the apartment owners associations?
we have our own drafted.
Okay, so did
They're
it
very,
say
very similar.
somewhere in there you've got 3 days from when the date of when you were served? It had to have
Of
said language
course,
like
yes,
that.
of course it does.
So
Yes,
okay, so we
it's very
just had a case
compliant.
which I talked about, and somebody filed a summary judgment motion against my client, and we defended it and we won because it said there's no confusion when the rent needs to be paid because it specifically stated 3 days from when you're served.
Correct.
But
But my question to you, if you know, is this retroactive to all cases or only from that ruling date?
retroactive to all cases. So if you
All
had the
cases. Okay,
same bad notice that was contained in the one that went to the appeals court, you would lose that case. It's retroactive.
got it. Well, fortunately, we settled. The tenant was willing to get out early, and the landlord liked that. So, then a secondary question, and this might be important to all of your clientele out there. Is this applicable to commercial property?
That's a good question. The case was decided for residential property, but if you had the same confusing notice for commercial property, I would think that the same ruling would apply. So if you had it where you just had a date on the notice and you say 3 days, which is what that said, it didn't say 3 days from when the notice was served, I think you would lose that case, even if it's commercial.
Well, good. Then we made a good decision. Thank you very much for reinforcing that.
All right, you take care. And we're moving on to Millie Aguilar. Or Aguirre. Millie, are you there?
Hi, how are you, Mr. Block?
Hello.
Nice. Once again, thank you much for doing these every Saturday. I watch you and I put the like button. First time talking to you. Can you hear me?
I hear you fine. What is your
Okay.
question, young sir?
I have two of them. The first one is that on your beginning of the statement, that is ridiculous about you being criminalized for if you forget to do a notice.
That's what it says in that tenant.
And the other one is the air conditioning part. Is it for all LA County?
No, again, and I emphasize this, it's only for unincorporated rental units in LA County.
That's
That you
another.
either have to put in an air conditioner or somehow make it with building materials so that the temperature will not exceed 82 degrees.
Does it have to be central air? It could be those window air conditioning.
Yeah, it could be window air conditioners, of course. You know, no one's going to go through the expense
Of course.
of installing central air. Yeah.
Yes. All right. Thank you very much for your information and have a good weekend and go Lakers.
Thank you, Sarah. I'm kind of like a duck out of water, you know, after the playoffs and the things where they're trying to get new players onto the team, but now it's kind of like the dog days of summer where we have to wait until training camp opens until October 1st. In any event, let's talk to Mohammed. How are you?
Hi, Mr. Block. How you doing, sir?
I am good, thank you.
Good. I just want to first thank that gentleman who said how to raise my hand. I've been suffering and wrestling with this button the whole time until a couple of minutes ago. And I want to thank you for your expertise. I had a case. I asked ChatGPT, who should I choose? Your name came the first. So I chose you. Now, my question, I have about 70 units, 70 doors. And recently, most of these people, they don't pay. The one who are leaving, they give 30 days notice. They don't pay the last month rent, and they say, use my deposit. How would I go about?
Well, the only thing you can do in that situation is to serve a 3-day notice and start the eviction immediately. That's your only option. Now, if you know for sure the tenant's going to get out, then what's the point at that point going through the expense of an eviction? But a lot of tenants will tell you that they're moving when they have no intention of moving because they're trying to stall you from taking any legal action. So that's the way I think you have to play it.
Yeah, I didn't have that problem. They say they leave and they leave. And since I have 70 units, and do I need to have to be a manager to manage them, or
No, darling, you own the units. It's your God-given right as a property owner.
Perfect. My last questions is that when you say unincorporated area, I live in Palos Verdes Peninsula, when it says unincorporated. When I bought it,
If you're, I would have to look it up, and I can't do that now. But either it's the city of the peninsula, or it's an unincorporated area. Okay.
yeah, perfect. Thank you, sir.
All right. Thank you. And let's see, Janice, how's the weather in New York?
It's hot, Dennis. Just like it is in LA, I guess, only at 57% humidity. But a couple of questions about this pernicious these photos that you have to supply the tenant before and after when they leave. Can those be sent electronically? Because I see now there's a company that's set up a business around entering those photos.
I don't see any problem with that, sending it electronically if you have the tenant's email address. What Janice is referring to is that under the new law for the state of California, if a tenant vacates a unit, you have to, assuming you're going to deduct something from the security deposit, you have to take pictures of how the unit looks as he exited, and then take pictures of the unit after you instituted the apartment back to rental, so it could be rented again. So yeah, you have to take those pictures, and they can be done electronically, or just include it with the security deposit itemization.
The other question is this law, if you want your rental unit back to live in, you have to be in it for a year of continuous residency. Has anyone tested the meaning of that? Does that mean you can never go on vacation while you're living in?
No, of course not. I mean, you still occupy your house I just was in Europe, as you might know, for a couple of weeks. I still was occupying the house, so.
But is there any outer limits to how much you have to occupy the house?
Well, I mean, obviously, if you're living in another location, okay, it's one thing if you're temporarily gone, but if you're living in another location, then you're not going to be in compliance with the law.
But would that be 6 months or 9 months or?
I think that would be excessive, yeah. I think if you're going on vacation, that's one thing. If you're going to be sleeping your head 6 months at another location, then I think you're not in compliance with the law.
Okay, thank you.
And thank you. Rudy Dvorak, how are you?
Hey, thanks for doing this. This is great. We're just a mom and pop little developer in LA, and we're in rent control in the city. We've got 2 move-outs that we've just recently
I heard
done.
you had 1,000 units.
No, we have 32 or so. We did our 21-day notice for those move-outs, and we didn't provide the pictures. So we're past that 21 days on one of the units by 3 or 4 days, and the other units by about 10 days or 15.
Has anybody complained?
Yeah, we got emails from both of them, and they're both very, very difficult.
I'll send it to them now, that's all.
Okay.
That's all you can do?
Yeah, the other thing is, what's the general court sentiment with this brand new law in terms of landlords?
Obviously, there is no court sentiment because it's a brand new law, so nobody's really tested it. But if you sent the security deposit itemization within 21 days, and then you sent the pictures a little bit later, I don't see a problem with that, especially if your deductions were legitimate.
Okay, very good. Thank you.
Thank you. And we are going to take Alan Zaman. How are you?
Hi, Dennis. I'm doing good. How are you doing?
I am fine, thank you.
Great, great. Thank you so much for all this amazing information. I just wanted some clarification on these non-RSO properties. Usually for buildings that are not under rent control in Los Angeles, does it apply to 1970 October 1st, 1978 or 1979?
Okay, it's October 1st, 1978. So any property built from that date forward in time is not subject to the rent stabilization ordinance, but it is subject to the just cause ordinance, and it could be also subject to statewide rent control.
I see. Got it. Okay. Thank you so much.
And thank you. Okay, I'm going to be generous and take one last caller. Ronnie, how are you?
Hi, Dennis.
Hello.
Can you hear me?
I can.
Hi, I just had one question. My tenant by accident left his utility running for 1 week when he went off on some vacation or something, and we got a humongous bill.
What was the utility?
It was like $300.
I'm saying,
Water.
but was it electricity? Like he left the air conditioning on?
No, he left water on.
So he left water running?
Yes,
So and just was going down the drain?
correct.
And he admits that he did this?
No, he doesn't admit it, but of course they don't admit it, but that's what the water company told me, that it was continuously for 1 week
What could
running.
I don't know how the water company would know that, but the
It was not a leak or anything like that. They knew,
but how do they know it was his unit versus someone else's unit?
oh, because there's only 2 units and he was the only one there.
Well, you know what? You could tell him, look, please reimburse me, or I'm going to sue you in small claims court. I think that's about all you can do with a situation
Okay.
like that.
All right, that's it. Thank you so much.
Thank you. I want to appreciate everybody coming out and making it through another edition of Zoom Landlord Tenant Talk Radio. Certainly appreciate all the participants because it does make the show. Again, if you guys are watching in the YouTube, I please ask you to like and hit the subscribe to the channel. And if you do have comments, please put it in there. And with that, I'm going to wish everybody a happy weekend.